Final panel for today discusses the role of experts in arbitration. The moderators for this session will be Mr. Vikram Nankani, who is a senior advocate with the Bombay High Court and was earlier the head of dispute resolution at Economic Laws Practice. Joining him as co-moderator is Mr. Shreyas Jayasimha, who is the founding partner of Aarna Law, a law firm specializing in international arbitration. As the speakers, we have Mr. Cecil Abraham, who's a senior partner of Cecil Abraham and Partners, Malaysia. We also have Mr. Anand Desai, who's the managing partner of DSK Legal, a leading law firm in India, and if I may say, an upcoming Bollywood actor with a small blink or miss role in Amir Khan's latest movie. We also have Mr. Matthew Gearing, who is the co-head of the Global Arbitration Group of Allen and Overy, based out of London. And finally, Mr. Howard Rosen, the Senior Managing Director of FTI Consulting and head of the Global International Group in the Economic and Financial Consulting segment of FTI Consulting. Thank you.
Good evening and thank you, friends. Lovely to see that we have such a large fan following. You know, this panel will be really obliged to you guys to sit here patiently for the last session. Message for those who are hanging out in the corridors. Please tell them that the organizers have made it sure that they won't get cocktails until the end of this session. So they may as well spend their time fruitfully here. The topic today is role of experts. More said about this topic, the less it is. And therefore, we are always going to find something different to say to and exchange the thoughts on the subject. There are many issues which arise in the context of experts. When do you really conceive the idea of having an expert in an arbitration? When do you brief an arbitration? What's the right time or the appropriate stage of the proceedings when you would consider having an expert as a witness in the proceedings? Is it at the beginning? Is it after the pleadings are completed? Is it at some later stage? And then, of course, what kind of brief would you give to the expert? The instructions that you would give. Would both parties give separate instructions? Would there be a common set of instructions? And then thereafter, the discussions between the experts. How would that be handled in a situation? Would the tribunal run the proceedings as far as the joint meeting is concerned? Would the party and their lawyers would have a bash at each other's experts? And then finally, of course, is the question which is often now cropping up in many proceedings, a clean expert versus a quote-unquote dirty expert. So can you have the presence of one expert sitting by your side who virtually plays the role of a fact witness, fully involved in the issues, fully involved in the subject matter of the claim, there to assist the party and the party counsel in trying to demolish the independent expert and thereby earning the popular tag of a dirty expert versus a clean, independent expert. These are some of the issues that we will grapple with today, and I'm sure that you are going to get a lot of gyan from the panel to my left. My co-moderator for the evening, Shreyas Jayasimha. Let me just kick off by posing the first question to Tantri Cecil Abraham. Tantri, when do you think the expert should be appointed? At what stage? And are you in favor of party-appointed experts or tribunal-appointed experts?
Good afternoon to everybody. And firstly, can I also join all the members of the panel in thanking the Mumbai Center for inviting us to speak this afternoon. To answer the question that is posed by Vikram, the issue is really whether a party-appointed expert is better or whether a tribunal expert is better. And this would really be answered in a different way, whether you ask the question of counsel or whether you ask the question to the tribunal. I would take the view that the appointment of individual experts by respective parties, the joint appointment of a single expert by the parties, or the appointment of an expert by a tribunal and even the appointment of individual experts by respective parties, and then coupled with tribunal-appointed neutral experts, has its advantages and disadvantages. And for this purpose, I think we really should look at the concerns of each mode of appointment. And some of the common concerns of each party appointing their respective experts, witnesses, could be briefly said to be as follows. Firstly, lack of impartiality. The common view is, I suppose, party-appointed experts are really seen as hired guns producing evidence brought by the party presenting it. And sometimes if you look at expert reports, it really looks and resembles the arguments of the party who has appointed them. Secondly, sometimes there is a lack of clarity in the reports, in that they are too long, too complex. And I suppose the reason is the party-appointed expert has been instructed by the party and not the tribunal, and of course they perhaps have a different perspective and focus compared with that of the tribunal. And sometimes there's a lack of coordination between the two experts appointed by the parties, and if they are submitted simultaneously, they may not even correspond with each other. They may be based on different facts, different scientific approaches, different assumptions, and sometimes they may not even address the issues. So it is really difficult sometimes for the tribunal to bridge this gap between the reports, maybe without the help of another expert. And some of the concerns insofar as a tribunal-appointed expert is, I suppose, counsel may distrust the appointment of the tribunal-appointed expert, in the sense that they have no control over the expert, and especially as to how they perceive critical elements of the case should be presented. The tribunal-appointed expert may also lack information. The flow of information between a party and his corresponding party-appointed expert is usually much more smoother than perhaps between the tribunal and the tribunal-appointed expert. There may be also lack of clarity and then different standards of impartiality and independence might arise. Now, if you look at modern arbitral practice in international arbitrations, I perceive that the use of party-appointed experts has really eclipsed the practice of leaving such appointments to the discretion of the tribunal. There are grounds really for both parties and the arbitrators to prefer party-appointed experts. And for the reasons I've already given, in the sense that there is greater control over the matters which will be put to the expert for his or her opinion, which arguably pars down the potential for irrelevant testimony, hopefully. For the tribunal, this approach may be preferred because it relieves the arbitrators of the logical and procedural responsibilities of appointing an expert. So I take the view that there are many counter-arguments against the use of party-appointed experts. In particular, one would see it as a development of the battle of experts, where two opposing experts testify, sometimes with diametrically opposed contradictory positions, and sometimes even using technical jargon that is almost irreconcilable. And tribunals may feel at a loss to determine which expert is correct. One should also consider the case of arbitrations involving both party-appointed experts and tribunal-appointed experts, where the question of technical expertise is required in an international arbitration, say in respect of liability and quantum. It is usual for parties to present their experts from the independent experts that they have retained. And then it is really up to the tribunal to weigh and compare the value of that expert testimony in order to reach a conclusion. However, as I said, sometimes the evidence of the experts is so technical, and the tribunal may have difficulty in reaching a decision. So they may, in those circumstances, seek the assistance of a neutral expert. But if they want to do that, either they do it at the outset of a complex case or a later stage. And so I would think that the tribunal should appoint and engage with the expert sooner than later, and in any event before the final hearing. This is so that the expert can present during the oral testimony of the party expert. Insofar as what stage it's best to engage with the tribunals, this should be done at the preliminary meeting or at case management, which should be held to try and narrow down the issues and contention in which the expert's evidence is required. And if it is necessary, one can hold further meetings or a number of meetings to try and narrow down the issues which are agreed in expert evidence, and also maybe with a number of experts that should be called in any hearing.
Yeah, the challenge, no doubt, in case of tribunal-appointed arbitrators is that the tribunal should be proactive. The tribunal should, if you say that the expert appointment should be made at the earliest, we are expecting the tribunal to have a fair degree of the issues involved, knowledge of the issues involved in the matter for them to take a decision as to an expert to be appointed and what type of expert to be appointed. In fact, and on the other hand, the party-appointed expert, Martin Hunter, to quote him, was very cynical when he said that the main disadvantage of an expert is that the expert evidence presented to the tribunal is bought by the party presenting it, and so it needs to be openly challenged for credibility through other mechanisms. So, Anand, could you just throw some light whether this is an area which requires some degree of regulation, maybe through soft laws or other mechanisms?
Thank you. I think the aspect of experts in arbitrations in India is a fairly recent phenomenon by and large compared to international arbitrations. And I think a lot of Indian experts believe that they're really acting for the party rather than being independent and giving an opinion that is independent. In terms of protocols, we don't have any as such in India. We have the law, of course. We have Section 45 of the Evidence Act, Section 26 of the Arbitration Act. In some institutional arbitrations, there's also further protocol guideline assistance in determining how they should conduct themselves. But possibly the whole issue of understanding the role amongst themselves as experts before they take on the assignment, and also the duty of the party concerned appointing the expert that please give your opinion as your independent expert opinion rather than just mouthing what I'm saying on the facts and fitting the expertise into that would help a lot. So I do think that a protocol would help. Guidelines often help because a lot of people are just ignorant as to what is expected of them when they get appointed in a place like India.
Yeah, there are CIR protocol. There is a CIR protocol on the use of party-appointed experts. So we have that guideline which can be very usefully used in a given case. Howard, from your experience, how would you reckon the appointment of an expert and an independent expert at that?
Thank you. So I've been an independent expert for over 35 years. And in the early days of my career, in the early 80s, most of my work, and I'm a financial expert, and most of my work was done in national courts in Canada and the US. And I used to hear the same kinds of complaints from judges and from counsel that experts were hired guns, that they knew who was paying them, and they tailored their opinions to suit their clients. And I think it's a cynical point of view. I think there's certainly some experts out there that would lead you to believe that we behave in this way. But there's a few things that protect the courts and clients and counsel from experts behaving in this manner. It's difficult in commercial arbitration to achieve the same result, but in the national courts, judges wrote opinions in their findings. And where experts behave badly, judges frequently cited the experts as being unhelpful, biased, just not good experts. The other thing that I think mitigates the risk of experts behaving in this manner is the fact that most experts belong to a professional organization, much like lawyers belong to a law society, and there's rules of ethics that govern the behavior of lawyers. I'm a chartered accountant and a chartered business evaluator, and the rules of my professional organization govern my behavior and govern what I can put in my reports and govern what it means to be an independent expert. And so I think when courts and counsel are looking at, or arbitral tribunals are looking at experts, they need to be thorough in understanding who these experts are. In national courts, to become an expert and offer expert opinion evidence to assist a court, you have to be qualified in most common law jurisdictions through a series of questions in voir dire. In international arbitration, there is no such process. If you've produced a report, you're assumed to be an expert. And so there's no gatekeeper keeping experts that don't have professional qualifications out other than instructing counsel. And certainly in treaty arbitration cases, which are public, we'll see decisions where certain experts are cited for being helpful or unhelpful to the tribunal. And that has a way of identifying those experts that are not behaving as experts should. So in answer to the original question, which is, should they be party appointed or should they be tribunal appointed? I think that the party appointment of experts allows the parties themselves to determine what kind of expert they want, what kind of background and experience they're looking for, and they have a sense of control over their own case. And they can decide on the cost and the risks associated with hiring their own experts. Tribunal appointed experts, I think, remove that optionality from clients and counsel. And again, if it's your case, I think you should be able to decide who the experts are that are going to assist you in the presentation of your case.
Yeah, I think there's an inbuilt mechanism or some kind of a sanction in the very appointment of an expert, because you cannot lose your independence and your integrity. And just to quote my friend Kabir Singh from his article, which he very usefully forwarded this afternoon to me, it says, experts are also less likely to make patently false statements when challenged by their peers for fear of being caught out and the associated reputational damage. So maybe there is no formal mechanism for an expert to file a declaration, but I think there is some kind of an inherent implied check in the system. Shreyas, would you like to take over?
Thank you. We have only one testifying expert on the panel, so he's going to get some more of these questions. Howard, we have so far, I know that you're a damages expert, but just for the benefit of the room, and since you run a large practice which has many types of experts, could you elaborate on the various types of experts that are in fact available to parties? And as proceedings get more complex, you might also wish to add to your response the time and at which these experts are appointed, to differentiate them from the advisory team and from the independent expert who might be testifying at a later stage. Over to you.
Thank you. Well, first, I think that most cases that I've seen globally are, if I can say, over-experted. There'll be too many experts retained. I'm on a case right now that has a hearing in February. There are 13 experts retained in support of the quantum claim. 13. Many of these issues are not matters of expertise that the tribunal requires expert opinion evidence to assist the tribunal in understanding the issues and arriving at a decision. So I think there has to be more rigor and discipline from counsel in simply saying, well, there's a bunch of issues here. I'm going to use an expert. And I don't know if it's an abundance of caution or a lack of understanding, or in some counsel's case, laziness in not dealing with these issues. But you cannot solve every issue in a case simply by hiring an expert. So the different kinds of experts that we run into, I'm a quantum expert, and so I have experience in economics, accounting, and finance valuation. I do a lot of industry work in certain types of industries, but I would not call myself an industry expert. And so I'm a subject matter expert, but in our firm or in other firms like ours, you'll find people that have industry experts. And they can be telecoms experts, oil and gas experts, mining experts, whatever kind of experts that come from those industries and have true expertise. They're not just people that know where to look things up and can assist a court in writing a report by looking up reference material. These are people that possess true expertise and can give opinions. And as I said in my last answer, there is no real gatekeeper in international arbitration that would qualify an expert. Anyone who produces a CV can call themselves an expert. And so in the selection of experts, counsel especially, because you are the gatekeepers initially, have to be very, very rigorous in examining the expert's credentials to ensure they actually have that kind of expertise. As for timing, it sounds like it's a little self-serving, but we always like to get involved as early on in the case as possible. I mean, the reason that you bring a case before an arbitral tribunal is principally to recover damages. There may be other reasons behind the case, but principally it's to achieve an award of damages or to avoid an award of damages. And so there may be a legal construct that you use in your case, but when it's analyzed from a quantum point of view, will not actually produce substantial damages or will expose your client to substantial damages. And so having an expert who can advise on the framework for damages sort of as the case evolves, as you discuss the legal theory, as opposed to after the arbitration is filed and the pleadings or the initial pleadings are completed, when you don't have an option of changing your strategy, in my opinion, is advisable. And there was reference to sort of the clean expert and the dirty expert. And certainly, you know, if you are a true independent expert coming to a tribunal to give an opinion, you should be free from bias or intent. You're not there to help your client win. You're there to assist the tribunal in understanding technical issues. And you should avoid the use of jargon, and your report should be short and they should be understandable. You know, a brilliant expert who's a brilliant analyst who can't communicate simply does not achieve much in a hearing. But these are the clean experts, the people who come as independent experts. But your case may require someone on the inside who can help you with strategy and to think about how your case should be presented from a quantum perspective and how to deal with the opposing side's quantum expert and how to deal with cross-examination of that expert. And so you may need someone who's an advisory expert who's not going to give you an opinion, and those are referred to as the dirty experts, rather.
Thanks for that. Matt, you've interviewed several experts as well. So can you share if there are any best practices in interviewing experts? Also, there are maybe confidential information that you need to share with the expert at the outset as a logistical matter, and at the same time you wish to retain their sense of independence. So over to you.
Thanks, Shreyas. Let me start deliberately by not answering your question, but by applauding Howard on something he said, which is it's extremely refreshing to hear an expert as esteemed as Howard saying that many cases are over-experted. I completely echo that. And I echo that often against myself because sometimes I think I'm responsible for ensuring cases cases become over-experted at the end of the day. But we all know how the bandwagon starts, and one expert leads to another. An 80-page report leads to a 100-page report, leads to a 120-page report in reply. So, Shreyas, in a roundabout way, my first answer would be to say, before you even interview an expert or even think about an expert, ask yourself once, twice, 3 times, do you really need an expert? I think in the area that Howard practices in quantum, it's less controversial because there are many exercises in quantum where you obviously do need an expert. You need an expert to convince a tribunal as to the validity of your DCF analysis. You need an expert to even tell you how much you can claim by way of lost profits. In many other areas, if you're dealing with jurisdictional merits, you should ask yourself extremely carefully whether expert evidence is required at all. Now, Shreyas, dealing more directly with your question, I think certainly when I'm involved in selecting experts, we look at two things. First of all, we look at genuine expertise, and secondly, we look at experience in giving evidence. And sometimes the two don't necessarily match up, because sometimes you can find someone, even from your past experience or a colleague's experience, or you'll reach out to other people in the room in gatherings like this, and someone will say, you know, I had a pipeline arbitration a year ago and I had a terrific expert, and you'll happen to have a pipeline arbitration, and off you will go and speak to that expert. Genuine expertise is what we would look for first of all, and I think if you don't know the expert, often a simple phone call and an exchange of emails maybe will be at least enough to get you up and running. But then you have the question of, well, how are they going to be in front of the tribunal? How are they going to write their reports, and how are they going to be in front of the tribunal? And in that case, of course, if you have seen them yourself, then of course that's the best recommendation. And in quantum, to mention quantum again, most of us are very used to seeing quantum experts. So most of us have our own ideas as to the quantum experts we like to see and we like to instruct. If you're going a bit off-piste into more difficult areas, then again you're perhaps going a little bit on faith and reputation rather than personal experience.
Just a quick follow-up with you on that, going slightly off-piste myself, which is the large practices such as perhaps your own firm and perhaps dealing with large expert bodies like Howard's firms. Do you see practices emerging on best practices to perhaps not instruct the same expert overtly beyond a certain set of number of matters? Yes. And is there a time gap that you keep between engaging one expert to going back to them again? Yeah. Is there practice emerging in the market?
I think it is. There are other representatives of big firms in this room, and they may also have a comment, but I think a rule, a soft rule, which is not bad to adopt, is to take the 3-in-3 rule, which has emerged for past appointments by arbitrators by the same council or the same party in respect of arbitrators, and apply that to experts. And very roughly within my firm, we will ask ourselves, well, have we appointed this expert, or I have to say this whole organisation, 3 times or so in the last 3 years? If we've appointed them more than 3 times or so in the last 3 years, then it's not that we definitely won't appoint them, but we will certainly consider whether someone else can fit the bill.
Thank you. Anand, you talk about the underutilization of experts in India, but do you see particular types of disputes where experts are underutilized with the, for example, the emergence of economic jurisprudence in competition law, and now perhaps the new oncoming follow-on claims apart from the pure claims that are existing within the competition law framework, or any other use of experts that you see?
Yeah, I think those are clearly very relevant topics where you need expertise to come in. We are also seeing much more complex contracts now in terms of large projects which have their own set of complexities in terms of technology, what is a liability, who is responsible, etc. I really believe for a lawyer or an arbitrator to have that expertise himself is highly unlikely. I think what's more exciting currently, at least for me, is when you have disputes involving technology. You have artificial intelligence coming up, you have blockchain coming up. And those are even more complex for people like us who have not understood how these things work. So technically, a simple thing, as an example, an email that's put into evidence. I think in India still very few people understand how an email can be traced, how the headers are supposed to be looked at, etc. So whether the email really was sent on that date and time or not itself is something that befuddles several lawyers and arbitrators. So with emerging technologies, with emerging areas, there's huge scope, necessity as well, to have experts, to my mind.
One point we can't miss out is the emergence of the Indian law, professional Indian law expert. There's a small body of people who are testifying on Indian law in Singapore courts, London courts, international arbitration seated elsewhere. Do you see a new breed of the Indian law expert, or is it still the retired Chief Justices who are the Indian law experts?
No, I think there are more and more coming out, which is good. The caution I put in my earlier answer continues, that often I see them putting in their opinion on the facts rather than limiting themselves to the law.
Well, I think in my experience, when we are dealing with the question of Indian law, Indian lawyers tend to go to retired judges of the Supreme Court to give evidence on those issues. I don't, I mean, I've only come across one or two instances when a senior advocate has been asked to give evidence, and then when he's ranged against a Chief Justice of an ex-Chief Justice of India, I suppose the tribunal sometimes has to decide who is to be given more weight as such. So I suppose for those reasons, we tend to see more and more ex-judges giving evidence on Indian law before arbitral tribunals. But perhaps one of the things is maybe professors of law should come before tribunals as well.
Yeah, thank you, Tantri. I am not as young and bold as Shreyas to raise a very controversial topic. So I'll move away from retired judges versus professors. And let me start at the beginning where the whole concept or thought process of getting an expert involved is concerned. Obviously, if one party puts his hand up to say that we are going to put in an expert, the other party, if not for any reason, will like to counterbalance it with an expert from their side. Now, there will obviously be an opportunity for joint meeting between the two experts, but in that joint meeting, are they going to be looking at two different poles, north and south? Because suddenly they discover and find out that there is very little in common on the instructions which were given to them. So what's the solution? Is the solution to prepare a joint common memo where both parties will agree on a set of questions to be sent out to the expert, and both experts would simultaneously give their views on those agreed questions? That is really a vexed issue. Matt, what are your views on this?
Thanks, Vikram. A couple of points. I think, again, in terms of controlling the proliferation of expert evidence, the 80 pages becoming 100 pages, becoming 120 pages, etc., the best way is to agree a common set of instructions at an early stage. First of all, you said that if one party wishes to put in an expert, I would challenge that, and I would say, certainly in this day and age, many tribunals, proactive tribunals, are saying, well, just because a party wishes to put in an expert, that isn't enough. The tribunal has to be satisfied that the admission of that expert evidence is going to materially assist. And this goes back to the old chestnut about arbitrators being proactive. If they're being proactive, if they've read in and they've thought about the case, they'll be more confident and they'll be more able to say, well, do you really need expert evidence in that area? But once you've got over that hurdle, whether the parties are just doing it and the tribunal's allowing it, or the tribunal's positively engaged in the process, then a joint memo and a joint set of instructions is obviously the way to go, because it avoids the two ships passing in the night phenomenon. But I have to say, it's still quite a rare thing that you actually see that. Again, because I think where there is a dispute between the parties as to what they want to tell their experts to do, it's quite rare that a tribunal would be confident enough to intervene at what would normally be a fairly early stage in the arbitration and resolve that dispute, and to say positively, no, the instructions will be this, or the instructions will be that. But if you can do it, and if the tribunal's engaged and the council are open-minded enough to allow it, joint instructions approved by the tribunal must be the way to go.
Any views, Howard?
Yeah, I feel pretty strongly about this. There's a lot of gamesmanship that goes on in the world of treaty arbitration right now, whereby a claimant expert will write a report based on instructions from counsel. Respondent will respond to that report with only a criticism, but not offer a positive view on damages at all. reply report is written by claimant's expert addressing those criticisms. And then in the rejoinder report, for the first time, respondent's expert will now put forth a different view of how to calculate damages and a different number, at which point claimant's expert doesn't have a chance to respond. And so you get this phenomena that we see frequently of two ships passing in the night, where a tribunal has the battle of the experts. One expert says it's worth 100, and the other expert says it's worth 0. And what's the tribunal to do? They look at the credentials of the experts. They're both well-credentialed experts. The reports sound plausible, sound reasonable. And in the absence of some very thorough investigation by the tribunal in witness conferencing, they're left with two reports that aren't very helpful. And so it's very, very frustrating to be an expert in those types of cases. Now, as a matter of course, if in one of the earlier procedural meetings, the tribunal takes an activist approach and says, I want to see the instructions counsels given to experts, and I want to make sure that you, as counsel, can instruct your experts to do whatever they do, but included in those instructions, we're instructing you to make sure that your experts respond to each other so that we get evidence on all of the issues from both experts. And so whether it's done as a joint letter of instruction to both experts, or whether counsel through the tribunal consolidates those two sets of instructions, it has to be done.
Yeah, in the interest of time, I'm not going to stick to the script, so let's go to the related topic, although the point which we had slotted for discussion and the next is also equally interesting on privilege in relation to experts. But moving on to the related topic of a joint memo, assuming we don't have that happy position of joint set of instructions to experts, we still have one more opportunity where the two experts could meet together and come up with common points of agreement or disagreement. But the moot point is that at such meetings, would you or would you not allow party counsels to remain present, or would you leave the two experts to be on their own and try and sort things out between themselves? What would you like to say on that? Anand, first let me get the Indian perspective. Have you had any experiences of such joint meetings, and have you seen any joint meetings happening without the counsel remaining present?
I have not seen one without counsel present, because the sense is the counsel have to govern what the experts are heading towards.
Matt, what are your views on this?
Yeah, I've seen many where experts meet without the counsel being present. Sitting here, of course, the correct thing to say is that counsel shouldn't be present, because well-briefed experts should be able to meet, and they should be able to collaborate, and they should be able to narrow areas of difference and then genuinely assist the tribunal, which is, of course, their function. I mean, that must be the right thing. Of course, when it comes down to it, and your counsel, and you know what are the good points of your case, and you think you know what are the less good points, then that becomes quite a difficult thing to allow. Although it does increasingly happen, but actually the critical thing, it seems to me, is not so much whether the experts meet on their own, whether by telephone or face-to-face without counsel, but it's whether the product of that meeting is presented to the tribunal without counsel getting involved. So if two experts meet, quite often, if they're both sensible people, will come to a measure of agreement on a number of points. If they produce a joint memo, which would then become something on the record which is sent to the tribunal without counsel getting involved, then that can genuinely cut through many issues. But if they have to, as is often the case, go back to counsel before they can sign off on that memo, then much of the progress which is made in the meeting is then undone when counsel gets involved in the memo. Something that Howard and others and I were discussing earlier. Howard, you said you had experience of that, I think.
Yes, I mean, very briefly, I've had many meetings with opposing experts in arbitration hearings, and where counsel attends the meetings and requires a review of the joint expert report, our input to it. any measure of agreement, any measure of progress is immediately undone in almost every case. And again, I know it's hard for counsel to lose a little bit of control and trust their experts to meet and act sensibly, and on issues that are not matters of law, that are just matters of whatever your expertise is, whether it's economics or engineering or whatever it is. You've hired your experts for a reason, and you trust their judgment. And you know, when we do a joint expert report, we can eliminate 2/3 of the issues usually if counsel does not get involved.
Thank you. Before we throw it open for questions, Tanshri, one last question to you. Do you as arbitrator have any expectations of the institution when it comes to experts? For example, there may be situations where institutions are called upon to appoint experts in the absence of agreement between the parties, or the tribunal not making that decision. So do you see any role for institutions at all when it comes to experts?
Well, I've never come across such a situation, because it's either the parties appoint the experts or the tribunal. I think those are really the two options that are open.
Quick reason for that was that there are, for example, appointing authority rules. LCIA has it, few other institutions have it, and though rare, arbitral institutions are in fact called upon to appoint experts. With that, may we open to the floor, please, for any questions? I see one at the back. Lady there.
Yeah, can you hand over the mic, please?
So more than a question, this is actually a comment that I'd like to make on something that was said earlier about the two experts, you know, like two ships passing each other in the night, and how respondent's expert rarely ever replies to claimant's expert, what Howard brought up. I just wanted to share an experience that I had recently in an investment arbitration case where something like this happened. And the tribunal then, because it was completely lost with all these conflicting figures and positions that were put to it by the two experts, asked the experts to quantify each objection that the respondent had to claimant's claims. So each of the experts actually presented the tribunal with a factual matrix. So the tribunal could actually choose and say, okay, if I retain this position, then this is the amount of the claim that could be knocked off, or this is the amount that could be added on. And in the end, that sort of gave the tribunal a good roadmap through the damages claim and helped them to come to an ultimate quantification of the claim, which they really appreciated in the end. So that could be a possible solution. It worked very well in this particular case, and I don't know if any of you have had experience with something like this. It would be interesting to hear about that.
So I can tell you my own experience. Experts are usually given 20 or 30 minutes to make a presentation to the tribunal before cross-examination. And in every single case where I testify, that's exactly what we do. We have basically a bar chart that starts with our number and reconciles to their number. And there's a different box and a different color for each one of the issues where we differ. A lot of the decisions, though, have an interactive effect. So you can give an approximation for each one of them, but it can't be exact. But it's very helpful for the tribunal, unless they disagree with both experts. And because in these cases, the experts have been so disagreeable, they may not rely on either of them, and then they have really no help. And you'll see in the reasons, when you read the awards, you'll see sometimes tribunals say, the experts really weren't that much help to us, but here's some evidence, and here's how we get to a number. But yes, that's something that experts should always do in every single case.
Yeah. Any more questions? Yes, please.
I think I'll be loud enough. My question is directed to Mr. Rosen. Oh, thank you. It's directed to Mr. Rosen. You mentioned about conflicting reports and additions, subtractions, variations. At least as far as the judiciary is concerned, at least in this country, we are more bothered with the truth. If the reports are manipulated, I don't think that it would give a correct picture in the award. After all, even an arbitrator wants to know the truth. And if it's an inconvenient truth in the report and it's not given, what do you do?
Well, what we try and do is we always try and bring it back to common sense. And a lot of people, when they read expert reports, get lost in the technical aspects of them. But in the end, arbitrators should always remember that the market ultimately determines the amount of the value of an asset or a business. And it has to make sense. If you've got a respondent expert that says there's a gold mine that's been expropriated, it's worth nothing or it's worth negative, that's obviously incorrect. I mean, it's a gold mine. We all want a gold mine. And so when we present our evidence, what we look for is we say, okay, we've valued something in a number of different ways and we've reconciled the number. And it could be a low number or a high number. It depends, what the facts are. But then what we look for are other indications of value in the marketplace to give some context to it, to give some common sense about it. When arbitrators hear technical evidence and read technical reports, if the expert's done their job, they should not be left wondering. They should really understand the basis of that particular valuation, and it should make sense in context. And if it doesn't, then the expert or the experts have not done their jobs. So that it should never feel like the truth gives you the wrong answer.
I think that's a fair answer because many times, even if the expert is objective, 6 is to one, 9 is to the other. So there are always two sides to the coin, and both are equally genuine. So that is a possibility. And with that, any more questions, please? One at the back. Sorry, right at the back, yeah. Okay. And you said George mentioned. Okay, so we'll come back to you, George. I think he's ready.
Hello. My question is something with regard to what Mr. Rosen has just discussed in the last question, and also something that came up in the second session. So if you have conflicting reports of experts that come out in arbitrations, is it that much more imperative, and is there merit in having experts who sit on the panel as arbitrators themselves to be able to cut down on the kind of jargon that comes out in, say, expert reports, and then actually bring out a clear award in finality when you have an arbitration proceeding?
So there's two schools of thought on whether experts should sit as the fourth arbitrator or even as the third arbitrator. I mean, I've done it twice. I've sat on an arbitral tribunal and as sole arbitrator, but these were on quantum issues. The con position is that the tribunal will just rely on the expert blindly to determine the quantum issues, and that the tribunal won't discharge their responsibility as lawyers and judges. And so that's the position I've heard that's sort of against having their own experts sit behind them on the tribunal and whisper in their ear. The positive side of that is, if there is someone up there that has a command of the technical jargon and the science behind the expert report, when the experts present their evidence, they're more likely to be completely transparent. But I think instead of going through the step of appointing an expert to the tribunal to advise them, and it's sort of going against my own self-interest, but I think the better way to ensure that you get a reconciliation between experts and frank disclosure from experts is to have witness conferencing, have the two experts sit side by side and allow the tribunal to put questions to them and say, okay, the expert A said this, expert B, what do you think? And have them have a conversation to reconcile their differences in front of the tribunal. You get a very full, frank discussion if you do that.
Matt, would you like to add something?
Just to say, I think in international commercial arbitration or in treaty arbitration, it's pretty rare to see an expert per se appointed as arbitrator, It does happen, but I've rarely seen it. I think most of the time you'll get a situation, you hope to get a situation where the arbitrators know something about the underlying issues. Gas price arbitrations, for example, are a case where you really wouldn't appoint an arbitrator who hadn't done at least several of those cases before. But it's rare that the arbitrator's knowledge of the issues will be so deep, so profound, as to dispense with the need to appoint an expert. And that's in a situation then you then go off and appoint an expert if you really need it.
Anand, could you think of this situation where an arbitrator doubles up, an expert doubles up his role and an award comes before an Indian court? What do you think would be the reaction?
Well, I think it's a very broad question. Depends on the nature of the dispute. But if it's a purely technical dispute, I think it would stand. You don't mind. Yeah. Okay.
So a person can wear two hats. George?
Thank you, Vikram. This is really to develop a point that Matthew Gearing made on expert selection and appointment. I think, in my mind at least, I think there's a distinction to be drawn between different types of expert. So you'll remember that Matthew made the 2 points that when he's looking for an expert, he's looking for somebody who's really well versed in the technical field, first and foremost, and then as a secondary matter would look at their testifying experience. And I think you were sort of alluding to the same point, so I don't think I disagree with you, Matthew, but I think just to sort of develop the point, I think that first one is really what it's all about, really. In certain areas, like quantum, what you get is very highly developed technical ability from people who are also very good at testifying, with teams behind them who are good at developing the material that's required to testify well. And so you get the highest quality technical analysis from the very same people who are experienced technical testifying experts. You also find it in areas like delay analysis in major construction disputes, or the sort of technical issues that go into bunker disputes in shipping disputes. But there are other types of experts in very technical areas where actually, in my opinion, the experts who have some testifying experience may not be actually the best people. They may not be as deeply embedded in that technical field and be able to give the right compelling analysis of a particular point. I had a case last year in which one of the fields of expertise that was required was soil analysis. And both sides instructed experts who were effectively academics, who had little to no testifying experience. Certainly the guy on our side had no testifying experience. They were very rough and ready because they'd never done this stuff before. We briefed them, but they weren't really familiar with what was required of them in this process. But it was much better to have two experts who really, really understood this particular academic field. So I think there are those two different areas. Some areas you want testifying experience. Some areas, actually, I would kind of move away from the ones with testifying experience.
On a slightly different note, but in a related context, you may have a very good expert who may turn out a very robust report, but when you put him in the box, he sort of crumbles and the whole case falls on his face. So when you are appointing an expert, how much weightage would you attach to his demeanor, his outlook, and his articulation and his heroism, if I may use that expression?
Can I just say something? So, I completely agree with what George says. I think you look for underlying expertise first, and then experience as an expert in the witness box second. All I would say is that I have noticed in recent times that the second factor is emphasized a lot. You find that there are now league tables or statistics published by institutions that say we had X hearings last year and our experts were cross-examined Y times. You know, they possibly wouldn't be doing that if the market didn't think it was important. So maybe George and I are in the minority in that regard, in thinking that you really primarily look for underlying expertise. Having said that, if your proposed expert has not given evidence before, of course you're going to probe a bit more really how they come across. but a simple conversation should elicit that. Do they articulate complicated concepts simply? Do they speak well, to put it shortly? And if they do, you probably would tend to think that combined with their expertise, they may be a good expert.
I'm afraid with that, we will have to close. Would you like to wrap up, Shreyas?
Just falls for me to say thank you, Vikram. Thank you to each of the panelists. As the audience saw, there's much more to experts than that very, very short word. And this is a conversation that just begun. On a lighter note, Howard said that experts always come last. So maybe to the organizers, this is a topic, even in arbitration, experts come last. So it's maybe in the next session, we could advance the session on experts. It always remains superficially addressed if it's in the last session. So with that, thank you very much to all our panelists and the organizers. Thank you.